Good morning, everyone. Good morning from Baker Botts, and welcome to our webinar entitled Appellate Reversal in ETP versus Enterprise. What does it mean? I am Tim Durst, and I am joined this morning by two of my colleagues, Jason Bennett and Louis Larison, and we welcome you to our event. Before we begin, just a couple of basics. We will have the listener line muted through the entirety of the program. In just a moment, you'll begin to see our slides, and on almost all of the slides, there's an email address at the bottom to which you can direct your questions. We will try to leave a few minutes at the end of our hour session this morning to allow for us to respond to questions that you may email in, so feel free to do that over the course of the next hour. As a result of attending our session this morning, you will be eligible to receive CLE credit, including some ethics credits, and we'll give the CLE announcement in the slide and announce the CLE code toward the end of the presentation. So with that, we will begin. Our panel this morning consists of the three of us. So it is myself and Louis Larison, who is another trial lawyer. I'm a trial lawyer in the Dallas office. Louis is a trial lawyer in the Houston office. And with us as well, because it's important, is from the transactional perspective, is Jason Bennett. Jason is a partner in our global projects group and has as his practice energy transactional matters. Let's see if we can get our slides working here. For some reason our screen is frozen. There we go. And you'll notice right here on this first slide the question line at the bottom that I mentioned to at the top. So we're going to bring to you a trial perspective as well as a transactional perspective. Here's a roadmap of where we're going today. We're going to talk a little bit about the state of the law in Texas as it relates to formation of partnerships. We will focus on the ETP versus enterprise case. That jury verdict and judgment received much attention when it was handed down, and some commentators say that a bell of warning was rung across the energy industry. We'll focus on the recent appellate court decision out of the Dallas Court of Appeals that reversed the trial court judgment and the extent to which that bell may have been unrung by the Court of Appeals. Importantly, our third item here will be the practical risk and some mitigation tips, and Jason will lead that part of the discussion as we think about ways that this court opinion may impact transactional practice in the energy sector. And finally, we'll wrap up with our ethics piece of the presentation and talk to you about ethical considerations for lawyers, both trial lawyers and corporate lawyers in this space. What we're talking about today could have well been ripped from the headlines from 30-some years ago. Our firm was involved in the Pennzoil versus Texaco case, working with Joe Jamail for Pennzoil, and that case was a huge jury verdict, and it turned on a handshake deal. And it, like the ETP versus Enterprise case, involved a draft agreement that said there would be no definitive agreement until the executed definitive agreements are signed. You'll see themes of that in what we talk about with ETP, and as I said, these are issues that have been discussed in Texas over the course of several decades now, preceding the Pennzoil versus Texaco case and continuing through today. You'll see from this list of issues that were in the news pages and in the reporter pages for the courts during the Pennzoil versus Texaco matter that many of these things are the items that we're still talking about today, including did the parties intend by their actions and communications to be bound, and the transaction was subject to execution of definitive agreements. So as we walk through what's going on with the state of law in Texas today, you'll see that there are historical roots to some of these issues that we're discussing. Let's start with just a quick overview of where partnership law in Texas has been over the last few years. On this slide, you'll see on the left-hand side a table that sets out the provisions or really the key points under the Texas Uniform Partnership Act and under Texas law, which was the prevailing legal landscape until 1994. Intent was a prime element under this scheme, and all 5 elements were required to be satisfied in order for the formation of a partnership. After 1994, and since 1994, the Texas Business Organizational Code, and particularly as interpreted by the Supreme Court in Ingram versus Deere, has been the prevailing law. Intent was demoted some from the TUPA scheme, and all of the factors are considered in their totality without any of them really being a trump. In fact, under the TBOC scheme, it is fair to say, and courts have described the fact that intent may not be required. An association of 2 or more persons to carry on a business for profit as owners, regardless of whether the persons intend to create a partnership, can be sufficient for formation of partnership under TBOC and Ingram versus Deere. So that brings us up to where things stood at the time of the trial in ETP versus Enterprise, and Louis Larison is going to drive from here to take us back into the details of that case briefly and then through the appellate court decision.
Thank you, Tim. Good morning, everyone. So where did things stand for the trial in the ETP? Number one, as Tim said, we know that partnerships can be formed by the actions of the parties. Because it is a totality of the circumstances inquiry, it is a very fact-intensive inquiry that is generally resolved by juries. And so the question that was really teed up in the Enterprise case is, can the parties contract around those fact questions? Or to put it another way, will the courts enforce a written disclaimer of partnership, even if there's conduct that may be inconsistent with that? So just briefly, let's talk about the background. I know that most of you are familiar with the facts of the case, but the case arises out of a 2011 series of agreements regarding between Enterprise and ETP regarding the possible development of a pipeline between Cushing and Houston. The parties undertook preliminary work toward that joint venture, but in August of 2011, Enterprise terminated the proposed joint venture and announced a competing but different pipeline project with Enbridge. ETP filed suit in September of 2011, and the real key issue is, did the parties have a formal enforceable partnership? And so it starts with the initial agreements that the parties signed, and these ended up being central to not only the trial, but also to the appellate decision that we'll discuss. And what is important about all 3 of the agreements on this slide is that they contain standard language stating that there was no deal until definitive agreements were executed. And so here we've got 2 examples of those agreements, and the term sheet up top is really one that plays a central role. You'll see that the term sheet had classic condition precedent language, no binding or enforceable obligations unless and until the parties have their respective board approvals and definitive agreements. And both of those conditions we'll talk about throughout the presentation, and this language is central to what the court and the appellate decision ultimately found. So after the agreements were entered in 2011, we get to what did the parties do. We know that they formed a joint integrated project team that worked on the viability of this project. We know that the parties issued joint press releases, jointly marketed the project, and also jointly secured commitments during the open season. But in August of 2011, Enterprise terminated the proposed JV. They did not get sufficient commitments from shippers in their view to make the project commercially viable. And then a month later is when the dispute starts. And so we fast forward to 2014 to the 1-month jury trial, and our next slide is the question, the only question the jury considered on partnership formation. And one important thing that will be a theme throughout our presentation today is the fact that the jury was deciding this question. The question was not decided on summary judgment in Enterprise's favor. That was denied. It was not decided on directed verdict. The court denied directed verdict, and it was not decided on a judgment notwithstanding the verdict. So the jury is who has to really wrestle with this question of whether a partnership has been formed or not. And you can see that the jury charge here tracks the TBOC factors that Tim reviewed earlier. Notice that there is no special treatment and no special consideration for the written agreement that we just reviewed. Rather, that is handled in number 2 on the screen, that is an expression of an intent to be partners in the business. So when we talk about the trial result that we got, this jury instruction really was an advantage for ETP, who during a month-long jury trial developed some powerful narratives about the conduct of the parties, whereas Enterprise was really arguing more based on the contract language. But Enterprise, at the trial and appellate level, said, well, wait a minute, what about the conditions precedent? The analysis should start and stop with our agreements. We bargained for these protections. We made it very clear that the parties would not have a partnership until the definitive agreements and board approval were sought. And it's undisputed in this case, and the appellate court talks about it, that neither of those conditions were fulfilled. There was never board approval. There were never definitive agreements. So you will see this issue, both at the trial level and the appellate level, be central. And Tim is going to tell us a little bit more about how the jury and the trial court grappled with this condition precedent issue.
So to segue from what Louis was just describing, this note came from the jury. This is the top part of the slide that I have up right now is the note that came from the jury. They were wondering what was the impact of the written agreements, and does it override the factors that are listed, meaning the term sheet, the confidentiality agreement, and the cost reimbursement agreement. So they were focused on those contracts and grappling apparently with the significance of those and whether they trumped other activity that was being presented to them in the form of evidence at the trial. The trial court's response, not atypical for a trial judge, and I'm sure after consulting with the trial lawyers and the parties, responded to the jury by telling them to read the charge. Pretty typical response, and it is, I think, a credit to the jury and hopefully some satisfaction or comfort for transactional lawyers that are out there that the jury was thinking about the contracts and dialing into what was their importance. As a practical matter, from the trial lawyer perspective, it is difficult in front of a jury to persuade them that inconsistent actions should be trumped by contract language. If you were to poll trial lawyers on the question, you would probably get a majority of them that would come back and choose juicy facts over dry contract language, that's just a reality of a jury trial. And what you see here from the jury in the ETP versus Enterprise case is that they were grappling with that. Enterprise had made an attempt before the jury was charged to have the court address this. And so what we have here is a jury instruction that was offered by Enterprise but rejected by Judge Tobolowsky that would have instructed the jury, would have put in the jury instructions, this instruction, quote, when parties agree to become partners only upon a contingency or condition, there can be no partnership until the happening of that contingency. Judge Tobolowsky did not so instruct the jury, and the court took the position that prefacing the partnership question on conditions precedent was not appropriate, and instead she submitted the charge and the instruction that Louis showed you a minute ago, which simply outlined the factors within the TBOC. So that left the trial lawyers to argue, and argue they did. Many of you have seen excerpts or reports of what went on in the courtroom, and you know that ETP's lawyer argued in closing that there were 90 instances when people said or took actions creating a partnership, and the lawyer that closed for ETP made an argument that if it looks like a duck and it walks like a duck and it sounds like a duck, then jury, you should use your own common sense and you know that it is a duck. That trial lawyer, Mike Lynn, gave me permission to use this graphic that he used in the closing of the trial, and his argument was that the boilerplate conditions precedent language was akin to hanging a sign around the neck of the duck that it's not a duck, but the jury should listen and watch and use its common sense in determining that, in fact, a partnership had been formed. So let's turn now back to the appellate proceedings and a review of what happened on appeal. Louis?
Sure. So on the appeal, for those of you who have read the decision, you know that the court focused on number one on our screen here, the question of whether there was a partnership that was formed. They reversed and rendered on that ground, so they did not reach the issues of damages. I want to show you a few of the excerpts from the parties' appellate briefs just to frame things for you, and you will see there's a contrast not only in terms of whether the appellate court should focus on the contract versus the conduct of the parties, but also who they believe should decide that question of formation between the judge and the jury. So first we go to Enterprise's brief, and Enterprise frames this as a trial court's refusal to enforce an unambiguous contract between the parties. Enterprise says that these are two sophisticated parties, we exercise our freedom of contract, and we bargained for protection against exactly this type of risk. That is, that a jury would come in and tell us whether or not we're in a partnership. Enterprise also makes the case that this decision, if upheld, is bad for public policy and it's bad for business in Texas, because you should not have to wait for a jury to tell you whether or not you're in a partnership on a case-by-case basis. And I'm sure there are some transactional lawyers on our call that would probably agree with that critique. The second big point that Enterprise made in the appellate proceedings is that although there is the TBOC factor list, there's nothing in that supplants the existing principles of conditions precedent. So the TBOC is not the sole source of law, and that conditions precedent should still be enforced to reverse this trial verdict. If we go to ETP, we see a very different perspective, as you might imagine. ETP says that the written agreements only create a fact issue for the jury to resolve, not the court. In their mind, if we look at the very last sentence that's highlighted, they say that the contract is not a silver bullet. It is just another factor that should be subsumed in that five-factor test laid out in the TBOC. And what Enterprise says is exactly what Tim was referring to, is that, yes, they had boilerplate agreements, but that the parties ran right through that in a race to the market for this new pipeline market. Enterprise, or ETP, also focused on the fact that the term sheet did not have a no oral modification clause. And so they say if you look at the five-factor test, there is overwhelming evidence of partnership through the parties' actions. So you see through these two briefs that the parties take very different views of not only what issues should go to partnership formation, but who should resolve the question of partnership formation. Many of you on the call come from different walks of the energy industry today. The amicus briefs also reflect that this was a closely watched case. And what was interesting about the amicus briefs is that many of them addressed the larger question of public policy and business climate in Texas. Targa Resources, for example, had a brief that was dedicated to the harm to the midstream industry if the ETP position on partnership formation would prevail. These parties say that enforcement of the written agreements would lead to the predictability, the clarity, and the safe zones that parties need to pursue these types of projects. And the briefs also raise an interesting question. If there is uncertainty about this partnership formation issue, whose job is it really to fix that or to provide certainty? Is it the job of the appellate courts, or is it the job of the legislature through an amendment to the partnership statute that we have? So that brings us to our decision, unanimous decision that was issued in July of 2017, where we know the court reversed the trial court's judgment and rendered that ETP take nothing. So there were a few things that jumped out to me from the decision. The first is that there was a 15-month gap between the oral argument in the case and the decision, which tells me that the court knows this was a closely watched case, a case that would have an impact on how all of you are doing your business and papering up your agreements, and they were careful in how they went about this and how they went about the opinion. The second thing that's important in terms of their analysis is that it's undisputed that the conditions precedent, board approval, the definitive agreements were not fulfilled in the case. So what the court really looked at is what is the impact of those unfulfilled conditions. And the court ultimately concluded that those prevent the formation of a partnership. So therefore, ETP, in order to prevail in the case, had to prove waiver of those conditions precedent. and the court found that on the record that the ETP did not prove that waiver. So what are some takeaways from the decision? There are arguments in the briefing, and there's some discussion in the opinion about which parties signed which agreements, what is the scope of those agreements, but really the court cut through some of that and focused on the letter agreement because the court found that it had the clearest language on conditions precedent. One big takeaway is that the court rejected ETP's argument that the TBOC is the sole source of law regarding partnership formation. The court said that existing principles of law, like conditions precedent, are still in play, can still be considered, and in fact, that was where they really focused their basis for their decision here. A third takeaway from a trial perspective is that this decision does represent a shift back away from a jury back to the judge. You will see if you have, for example, an agreement like the term sheet that we saw and the letter agreement that we saw in this case, trial lawyers defending these types of claims will now have an opportunity to get out at summary judgment. They will now have an opportunity to say, Judge, this is a directed verdict case, that these are unambiguous terms that the parties agreed to, and it is the job of the court to enforce those terms as written. So I think there is a shift in terms of who's now making the decision on partnership formation. Not all the time, but at least some of the time, defendants will be able to go to the court and say, you should be the one making this decision. The other big takeaway, and Tim and Jason, I think, will talk more about it, but this decision does shift, I think, some deference back to the parties' intent in the written contracts. Obviously, the court here said they had written contracts in place. There were conditions precedent, they're unfulfilled, so there is no partnership. But the court did not close the door completely. We will talk about, and you'll see the red language at the bottom of your slide, they acknowledge that certain circumstances can amount to waiver of those conditions. And so Tim is now going to discuss how the court transitioned from discussion of the partnership formation question and segued into the discussion of can those conditions be waived and how.
So one takeaway is the Court of Appeals sort of rejected this walks like a duck, looks like a duck, sounds like a duck, and at least on the record as this case was tried, concluded that sometimes it isn't a duck, and concluded that the jury should have been asked whether there was a waiver of the conditions precedent. That was the conclusion of the Court of Appeals. This slide is a little bit of insight and sort of Monday morning quarterbacking, if you will, from us in terms of what such a jury instruction and sample question might have looked like. What we have here is the Texas pattern jury charge instruction on waiver, that it is an intentional surrender of a known right or intentional conduct inconsistent with claiming the right. That's what constitutes waiver in Texas, and so we don't know exactly what would have satisfied the Court of Appeals, and the Court of Appeals didn't specify, but the Court of Appeals did suggest that the jury should have been asked about the waiver argument, and a sample question to the jury on waiver may have looked something, could look something like what we have set out here. Did the defendant, by words or conduct, waive its right to require definitive agreements and board approval before a partnership could be formed? The way the Court of Appeals decision reads, had that question been asked and answered affirmatively by the jury, at least the analysis of the Court of Appeals would have had to be different. So as a go forward lesson, if you will, if we're trying cases that involve these conditions precedent and you're on the side of a party that needs to get around the conditions precedent, we're going to have to, if you can't get there on the law with the judge and you're trying the case to the jury, you're going to have to get jury input on whether the conditions were waived. So with that, I think we will sort of wrap up our discussion of what's happening with ETP and Enterprise. You see that the case is moving along. Motions for rehearing in the Dallas Court of Appeals are due the 1st of September, and ETP in its 10Q has already announced that it intends to file a petition for review with the Supreme Court. So that leaves the rest of us grappling with the legal landscape as it exists at the moment. And frankly, this is perhaps the heart of the practical impact of our or practical advice of our presentation this morning. We want to turn over to Jason to lead us through a discussion of some mitigation, risk mitigation tactics.
Morning, everyone. As Tim said earlier, I work in the transactional field, and after the excitement and sometimes devastation of litigation occurs, it's up to the rest of us to deal with the falling out. And this means, for most of you who are transactional attorneys, on a day-to-day basis, you're dealing not only with your counterparties, but your own commercial teams and trying to direct them in the right way. And I think the first piece of advice I would give you is to take away from what Louis and Tim have said, is this is not over. Like, do not let anyone believe that because of this ruling that all the best practices you've been trying to push onto your team and all the advice you've been giving them about being careful and the risk that this faces is somehow gone. It is not. I think talking about when a condition can be waived, once again, factual circumstances. Had that come up at trial, had that come up in directed questions, who knows how this might have come out. So you need to be very careful. Your diligence on these issues needs to continue. And so I think that's an important point, is to not let the commercial teams and others within companies get carried away that we just throw some condition precedents in the term sheets, we're all good. So before I start going through some of the tips for initial documents, just a word about LOIs, letters of intent, or MOUs, memorandums of understanding. As those of you in the transactional field know, these are often the early documents that you sign, and often emblazoned across the top is non-binding LOI, non-binding MOU. What does that really mean? Well, it means that there are provisions in there that are not binding, like, do we have to reach a deal? That's not binding. The terms of the deal, should we reach it? Those are non-binding. Should we enter into a joint venture, the term sheet attached to the LOI or MOU, those terms are not binding until we enter into an MOU or an LOI. Those are not binding, but the MOU terms themselves, in other words, what have the parties have agreed with respect to your actions between the day you sign it and the day you might or might not enter into a joint venture or some other project development agreement or other form of mini joint venture, those terms are binding. And so what we're talking about are terms you should include, especially when you're getting into joint activity with other parties. And so some of these are exactly the same as the things you've seen before. So you should obviously state the intention not to become a partnership, make it applicable to all parties and their affiliates. Sometimes on the front end you have some wings of the company doing the early agreements and other wings or affiliates coming into a potential joint venture or joint ownership and operation arrangement later. So go ahead and make that intention and waiver very clear that it applies to all of the companies. So consider disclaiming fiduciary duties, probably stronger than consider, right? You probably should be disclaiming them, or similar duties, opportunity, doctrine, obligation to enter into the agreement. How this usually looks is something like no agreement will exist till the parties have entered into these definitive agreements, and they shall have no obligation to enter into them, which shall be subject to the consent of the board, approval of their board, and the signing and delivery of agreements, things like that. Some of the exact language which was used in the enterprise ETP arrangements. Clearly state the conditions precedent establishing these. I think there will become a lot, because of the way this ruling is set out, there will be more scrutiny on whether there were actually conditions precedent or whether the language that was discussed between the parties was just an intention that maybe some other things would be done at a later date as well. And I think this comes into, for those of you in the transactional business, you'll understand when you're doing a joint activity, especially a joint project development activity, there's sometimes kind of an early joint venture and a later joint venture. And the earlier joint venture has to do with spending money to see if there's a viable project that you can do together. and you want to bring in a party, or they want to work with you, and you're both going to put some money in and maybe form some teams to work together, and those teams will do the exploratory work, maybe negotiate some arrangements with some contractors, feasibility studies often done at this stage, and then once that continues for a while, you bundle that up, and at some point you decide, okay, we're going to enter into a real, you know, LLC agreement or a joint venture agreement or shareholders agreement or whatever the flavor of arrangement is that looks like a partnership between the two of you to undertake the activities. And so that both of those events in and of themselves could be argued to be partnerships. Both of them are different in nature, and I think that's something that the court didn't really fully get to here, but an element which I think is very interesting is whether an early phase joint venture to just spend money together and that's it, and that somehow became a partnership, whether that really taints the second joint venture, whether that's any proof that a second joint venture to actually undertake the project ever really occurred. And by good drafting at the LOI and MOU phase, you can make this a lot more clear in the full context of the MOU or LOI. So I think that it's more than just the conditions precedent, and they're not a get-out-of-jail-free card. You need to make the whole relationship and the stages of work you're planning to do together clear if you don't want there to be a partnership, to give yourself the best chance later to argue not only the law but the facts. So they shouldn't, these conditions shouldn't sound like introductory or boilerplate contract language. Make them as specific and tailor them to your deal. The next set of suggestions, I think, for transactional lawyers is consider having a drop-dead date if the conditions aren't met. And when you reach that drop-dead date, even if it's an automatic drop-dead date, it's probably good to send a letter and say, we're all done here. This venture didn't reach commercial viability, or the parties, you know, we've decided we're not going forward with it, just to make sure the factual record is clear. You need the language saying no amendment or waiver through conduct, and it should also go on to say amendment or waiver must be in writing. We've included a sample clause in a couple of slides that we'll look at. It should have covenants not to sue. I put and indemnity here. There is tension, as you know, from your commercial teams and from the desire to strike a deal with others, that the MOU not itself become a major negotiation, and that the parties not put divisive terms in there. So you will probably come under pressure, and probably many of you have, from other wings of the company to say, what are we doing? We've got a 5-page MOU and a 2-page term sheet. Well, the deal is the term sheet, and it's got subject to contract on the top of it. So what are we futzing around with this MOU and sending over big clauses about not suing each other and indemnities, saying if you do sue me for these terms, well, then, you know, you're going to indemnify me for costs. You know, this is messing up our deal. You will come under immense pressure. I can tell you as outside counsel, we come under pressure, and there's a balance between commerciality and the law. But in this case, when you're dealing with joint venture-like activities, I think it's incumbent upon all of the transactional lawyers to make sure that those who are making decisions to cut down and to try to stay more commercial and to get the deal done understand the potential consequences. And we'll get to that in the ethics discussion. So one piece that wasn't really covered by this case, but I think is one that is worth noting since we're talking about joint venture-like arrangements or joint activity arrangements, is third parties. So the two of you, this case really deals with Enterprise and ETP and their interactions with each other and what the result was with respect to the two of them. The more common case where this comes up is when two parties are undertaking joint activity and one of them goes and does something with a third party. It could be tort-like behavior, it could be some other contractual breach where they've hired someone to work on the deal, or they marketed to someone independently of their partner, and the third party comes in and says, well, I'm suing both of you. I can't figure out who's who, and I don't really care whether you think you formed a joint venture. It appeared to me that I was doing business with both of you, and you're jointly and severally liable. And I don't really care what you wrote in your documents. I'm suing everyone, and we'll let the courts sort this out. right? In that case, you don't have the ability to choose your law and your forum and all the things that you don't have to, the contractual protections, right? You've set yourself up as joint venture parties, and if you've gone out to the market and made that pronouncement and said, we've got this joint venture and we're operating together, the terms you get vis-a-vis third parties cannot be contracted around. So you only have really your conduct and maybe the indemnities and cross-indemnities you get even in these early stage agreements. The two of you plan to go out to market together and say something about your joint activities, well, you know, third parties are going to hear it and they may respond accordingly. So you need to think through how you would want potential breaches among the parties, how that would look if a third party comes forward and says, look, I know I was just talking to your counterparty, but I thought I was talking to the joint venture, and so you're roped in here too. Once again, it goes back to indemnities, which are not the most pleasant early terms for a deal, but these are risks you have to think about. And obviously, vis-a-vis your counterparty, choice of law, forum selection, arbitration, I mean, if you don't want a jury deciding this, say so, right? You don't have to have a jury deciding it. If you don't want it in the courts at all, say so, and be clear about it, and then think through the consequences and the costs and timing of arbitration as well. So a couple of just practical pieces of drafting to consider. No waiver without writing. I think we pulled this from a contract, an existing contract, so there's nothing. This is probably even more overwrought than a lot of these clauses. You don't have to use you don't have to use as many words to get to the same result, but all the elements need to get there. It needs to be say something about the no waiver without an express writing. You can say signed by the parties, but that helps. You know, it's not always necessary to win the day. No waiver is construed that's not expressly identified in the written waiver. No failure to exercise or delay in exercising will operate as a waiver, and then there's no one waiver leads to other waivers. These are common elements no matter how drafted. The second one is covenant not to sue for partnership based on preliminary agreement. So this clause has lead-in language in the black there that is typical, and then we've added that's typical of any sort of covenant. And then at the end there, we've added, what are we covenanting to do? We're covenanting that one of the parties is not going to sue the other one claiming that a partnership exists. And as I said before, you could tack onto this and indemnifies the other party if party A brings a claim against party B that a partnership existed. Not only would they have waived and covenanted not to bring that claim, but they would indemnify for any costs and liabilities arising from it. It's just creating a much better trail and potential reallocation of costs for litigation if the dispute goes forward. Most important, and the one that I think you should focus on, is how to behave. And there is I'm a project development attorney and deal with oil and gas and energy sector generally. And there, as those of you on the phone know who work in this sector, there is a great push to announce that some sort of deal has been reached between counterparties to develop or look at something. It is both of value to the companies, but it also signals to the market that customers who want those services, they know who to call. And that if you're beating competitors to the market, you want the customers and those who you might serve to know. And it's a sign to contractors that you're a serious player and you have serious intentions. And as lawyers, transactional lawyers, we fully understand that. And as those of you who are in-house, I'm sure it's well explained to you. You understand the pressure that creates. That being said, there is a standard of conduct that needs to be observed. And it starts with knowing what jurisdiction's laws govern your agreements. Well, I mean, if it's written in the agreement, that seems pretty clear. But remember, if you're doing business with someone from another state, and you're doing so at an early stage and don't paper it up till a later stage, or your activities start to look like they involve another jurisdiction more, I mean, you've got to think through the risks involved there. Train your teams on how to conduct business during the LOI phase, and this is really tough stuff. Those of you who work with press releases know that a lot of time and attention goes into the press release, especially for public companies. What's there, what's not there, what's said, how it's said. And so those seem to draw the right level of attention, if not, excessive amount of attention from management. But Analyst calls, another one that seems to have a lot of attention to it, that a lot of preparation goes into. Conferences, I tell you, it's hit or miss. I go to a lot of conferences, and some companies are extremely scripted and are very careful about everything they say. Others are out there trying to get suppliers and counterparties and customers to come talk to them, and they're a bit loose in what they say. They're more likely to say, hey, we've got this joint venture we're jointly developing, or our partner in this deal, or our joint venture partner, and they use language which goes out to the market, and you have to worry about the third parties. You also have to worry about the factual record. And I know conferences can be boring enough as it stands, but you as the lawyers have to at least, I think our duty is to prepare our clients, whether internal or external, to go to these conferences and to use the right language. And it goes back to the LOI or MOU or whatever other preliminary agreement you're operating under. Read the language there. Read what you said about your joint arrangements there. Mirror that in what you're saying to the public. Right? Don't say different things, because that creates a factual record which could be used against you. So be true to your documents. All right? If it's not a partnership, don't call it a partnership. You say we're jointly considering the development of a petrochemical facility or whatever it is you're doing. Then that's what you're doing. The two of you are jointly considering it, and you're going to approach a decision about the commerciality of the project in Q3 of 2018. Right? That's what you're doing. Say something like that. So watch your conduct and communications with those third parties. Avoid the public appearance of partnership. And if you, we'll get to this in a second in ethics, and if you're overruled on the point and the business people in the company think that the contractual protections are sufficient and we need to speak more strongly about our joint activity, especially if it's progressing extremely well, that sort of thing, that's their decision, right? That's a decision of the company. I have to live with that. You have to live with that as in-house counsel all the time. But they need to understand the risks. And let me...
So, Jason, it's Tim. I might jump in here and say, this type of litigation, like, frankly, all types of litigation, we're dealing with less formal means of communication regularly as well. So email, of course, will be part of every case that gets tried these days. And this presents a real practical quandary, as you're saying, as transactional lawyers inside and outside try to balance the practicality of managing legal risk on the one hand versus the commercial interests on the other, which are really the dog in most instances, with the legal pieces being the tail. And so it is. I think this is a hard thing for lawyers to find the right rhythm and pace on. It does seem to me that one possible approach to this, and may be practical, at least in some circumstances, is to convene the team at the outset and just have a training session and say, what your actions here are going to be scrutinized. We need to be careful and mindful of what we've said in our documents and what the real legal structure is, and do everything we can to behave accordingly. And that might be a step that could be done in a relatively brief way by lawyers at the outset that could have some practical advantage down the road.
I think, Tim, the best companies, the companies that we work with that do this the best, and that really, quite frankly, do transactions the best, are ones where the in-house lawyers are well integrated into functioning commercial teams, and they understand the commercial rhythm and are sensitive to it, but they're also there to give timely advice rather than to hear about it later, or to hear, well, you didn't understand, we needed to move from A to B. Well, if you're in the room, it helps you to understand. I think companies that do this well, legal, whether internal or external, does not become an impediment to doing deals, but gives the good advice and helps get deals done in the right way. And I think this is a great example of it. And I think this is just this case and the fallout from it, which, as I said, I don't believe is entirely over, is something that is just another warning that these two wings of the company need to be working in concert with each other. So how does this affect us ethically? For those of you who are lawyers on the call, it is your duty when advising to exercise independent professional judgment and to render candid advice. And so what does that mean? I think comment 1, the last line, is very important here. A lawyer should not be deterred from giving candid advice by the prospect. The advice will be unpalatable to the client. Now I think this is a really tough line for external counsel because we want to help our clients get deals done, and we don't want to be emperor no over here, constantly saying what companies cannot do rather than what they can do. But candid advice is both about an understanding of what's commercial, understanding the position of the parties, but being clear about the risk that this might bring up for the company and where that risk might come from, whether it's the counterparty or third parties, and then how to mitigate that risk. If the company's intent on a particular course, talking about how you can get from A to B in maybe a different way. So Rule 103B about communication is about explaining the matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. So you have to review the important provisions with the client before proceeding to an agreement, and that means, I think, for in-house counsel that this initial kickoff that Tim suggests and a discussion of we're thinking about something that other people would describe as a joint venture, even an early joint venture, even a small joint venture, to examine the possibility of doing something. What steps will there be, and how should we look at this? How should we look at the agreement, and how should we set up our relationship with the other party, both structurally and in contract, to stick to it? And I think going through that at the very start is not only an ethical way to do it, but the right way to do it in practical terms. Monitoring behavior. The language here, however, when a lawyer knows the client proposes a course of action is likely to result in substantial adverse legal consequences, duty to the client may require the lawyer act. So this happens when we're not, it happens to us as an outside counsel when we're not being asked for this particular piece of advice. They say, look over this term sheet. You guys do a lot of these kinds of deals, and kind of tell us, you know, what's in the term sheet. Well, it's a term sheet. Written at the top is subject to contract, and there's no signature line. Well, okay, what they don't want is for me to ship back a 6-page MOU, which attaches to the top of it, has signature pages, has the term sheet on the back as an addendum to the MOU, and the MOU has all the things that protect them. But I think what it means for us is we need to talk to them about what this MOU or what this term sheet is trying to do, and why an MOU would be necessary, and how the term sheet will be used. Because I've seen parties say, oh yeah, we're going to come back, we'll do that whole MOU thing later. Right now we're just talking about terms, and that happens all the time. There's nothing wrong with that. But at some point, the parties start doing things in accordance with the term sheet. They've sort of reached agreement, no one signed anything, and everybody's starting to spend money or act in a certain way, and they say, we'll put all the procedures and process in place, but we need to get going, there's an expediency to this, that sort of thing. And this is where events start overtaking the lawyers, and you really feel like now we're kind of out over our skis a bit, and what can we do to reel it back? And I think this is where an early discussion of the risks, even if the company or your commercial team or the executive suite decides to move forward, an early discussion of them is your ethical duty, and also I think fits with the duties inside your company. And then it's important to remember that under 112, the comment 6 makes it clear, decisions concerning policy and operations, including ones entailing serious risk, are not as such the lawyer's province. So you will be, and we are, overruled from time to time on things we'd like to see in these term sheets, and these MOUs, and these LOIs. And so that's okay. Your duty is to give good advice and to try to continuously prod your team to be careful about this, but it will be overridden from time to time, and that's okay. That's not necessarily on you. Those are decisions which companies have the right to take. So now I'm going to turn it back over to Tim, and he's going to cover some ethical litigation risks.
So let's look at some ethical issues from the litigation perspective, and the piece here that we wanted to focus on really are preservation issues and litigation holds. We've identified for you here a couple of the ABA model rules, 3.4 and 8.4, with respect to preservation of evidence. But you know, from the practical perspective, the deal lawyers, the transactional lawyers, both inside counsel and outside counsel, have to anticipate that if litigation erupts, that the discovery battle is coming to their doorstep. It's coming to the doorstep of the people involved in the negotiations. So all of what we've talked about here in terms of practical tips and Jason's suggestion that the lawyers be involved from the outset are good, solid, practical ways of approaching things. It comes with some additional responsibilities or some consequences, and that is that you have to be careful about what is, what documents and what electronic evidence trail you are creating, and you have to anticipate that it all needs to be preserved. So you have to preserve. And if the lawyers are part of the deal negotiating team, then you're going to encounter some sometimes thorny privilege issues as well. But the last thing you want to do is position your company or your client to be in a situation where you're facing a jury trial and that the jury's deliberation may be colored by instruction from the judge about spoliation of evidence. If evidence is not preserved, and particularly if it's intentionally destroyed, the remedies can be harsh. And so what we have set out here is the Federal Rule 37E with respect to remedies that the courts can impose upon parties that fail to abide by their preservation responsibilities. There is not an exact analog to this in the Texas rules. Probably the closest one is Rule 215.2, which does give the court some discretion in what remedies are appropriate if evidence has not been properly preserved or has been intentionally destroyed. But these are things that to have in the back of your mind not only as you go into litigation, but even before that as you move through the process. So, part of that training exercise that we've talked about in the beginning can be a reminder to your business teams that what they're doing on a day-to-day basis may fall under scrutiny, and the company is going to have an obligation to preserve and turn those items over in discovery, and that can be an additional emphasis, particularly if you've got business drivers or business leaders who've been through the deposition or the discovery process previously. They're going to have memories of that will maybe impact their behavior going forward. So we just wanted to emphasize here some of the ethical responsibilities as it relates to preservation of evidence, and that leads us to our CLE confirmation information. I wanted to display here what credit is available, and I need to give you the code as well. So our CLE code is 58633. For those of you who are applying for CLE credit, you'll need to note this on your affirmation form to earn the proper number of credits, and there will be participatory ethics credit available to you for participating in today's event. That code again is 58633. And as we wrap up, I wanted to offer thanks and appreciation to a couple of people that are not shown here on this slide and have been huge contributors to us. Lauren Vasquez in our client relations group has been critical to this presentation, and substantively very critical to us has been Liam O'Rourke, as he has driven us the substance of this. And I also want to give thanks to Barnes and Roberts, who are my favorite trial graphics people, who helped us with the graphics for this. So again, the CLE code is 58633.